AI is not creating a loophole for financial advice. That is the first thing advisors need to understand. The early legal and regulatory pattern is not saying AI changes everything, so the old standards disappear. It is saying almost the opposite. AI does not erase advisor responsibility, it increases the need to prove it. The tool may help generate language. It may help summarize data. It may help draft recommendations, client communications, workflows, or analysis. But the advisor still owns the judgment. The firm still owns the claim, and the client still lives with the consequence. That is the shift. We are not moving into a world where AI removes accountability. We are moving into a world where accountability has to become more visible. The pattern so far is simple. AI is being judged through existing advisor law, not some brand new AI only legal framework. The existing standards still matter. Fiduciary duty still matters. Disclosure still matters. Supervision still matters. Books, records, documentation, and proof still matter. So when an advisor says we use AI, the next question becomes how, where, for what purpose, who reviews it, what claims are being made, what client data is being used, what gets documented, what happens before something reaches the client. That is the heart of this issue. AI does not replace responsibility. It makes responsibility more visible. And for advisors, that means the competitive advantage is not just using AI. The advantage is being able to prove how AI supports better stewardship. The cleanest early precedent is AI washing. The SEC has already acted when firms made AI claims that overstated reality. Delphia and Global Predictions became a warning shot. The issue was not simply that they mentioned AI. The issue was that their AI related claims did not match what regulators said was actually happening. That matters because a lot of firms are tempted to use AI language as marketing shortcuts. AI powered, AI driven, a proprietary AI, advanced AI, intelligent planning, personalized by AI. Those phrases may sound impressive, but now they carry a proof risk. If an advisor firm says AI is part of the value proposition, they need to be able to show what that actually means. What does the AI do? What does it not do? Where does human judgment enter? What is reviewed? What is disclosed? What is retained? The lesson is simple. Do not market AI capabilities you cannot prove. This did not start with generative AI. Robo-adviser enforcement actions already established the broader pattern. Automation does not lower the standard. Wealthfront and Hedgeable showed that software-based advice still lives under advisor obligations. The fact that advice is delivered through software does not remove the duty. It does not remove the need for accurate disclosures. It does not remove the need for compliance systems. It does not remove fiduciary obligations. It does not remove the client impact. That is the real message for advisors today. The tool can be automated, the duty is not. And this is where a lot of AI conversations get shallow because people focus on the technology and what technology can produce. But regulators care about what the firm claimed, what the client understood, and what the system actually did, and whether the process was supervised. So the question is not, can AI generate this? The better question is, can the advisor prove this deserved to reach the client? Right now, there is no clean standalone AI rulebook for financial advice. The SEC withdrew its predictive data analytics proposal for 2025. That does not mean AI is unregulated. It means existing advisor law still governs. Existing anti-fraud rules still apply. Fiduciary obligations still apply. Marketing rules still apply. Supervision still applies. Books and record obligations still apply. Privacy and vendor oversight still apply. So advisors should not wait for a perfect AI rulebook before they build responsible habits. That's the wrong waiting game. The real risk is assuming there is a safe harbor because the rules are still evolving. The absence of a final standalone AI rulebook does not create freedom from responsibility. It creates a need for better judgment, better documentation, and better proof. No new AI safe harbor, existing advisor law still governs. Regulators are already looking at AI as an exam, supervision, and governance issue. For advisors, that includes AI use in portfolio management, trading, marketing, compliance, and client communication. They are looking at whether AI related representations are accurate. They are looking at policies, procedures. FINRA is looking at supervision of Gen AI use, communications, record keeping, reliability, accuracy, and output review. And Regulation SP brings another layer: client information protection, incident response, service provider oversight, notice obligations. That matters because AI is not just a content tool. It touches governance, it touches records, it touches privacy, it touches vendor risk, it touches client trust. So the advisor's working rule should be simple: do not put sensitive client information into unapproved tools. Do not let AI outputs go directly to clients without review. Do not make AI claims the firm cannot support. Do not allow convenience to outrun stewardship. AI use is now a governance and documentation issue. So, what does this mean practically? Advisors need a proof stack, not because they're trying to become compliance officers, because they need to make their judgment visible. They need to be able to prove what the firm said AI does. They need to prove what client facts support the advice. They need to prove what assumptions made the recommendation valid. They need to prove what changed before execution. They need to prove who reviewed, approved, revised, paused, escalated, or blocked the action. And they need to prove why the action still deserved to happen. That is the bridge between AI and advisor value. AI can generate the recommendation, but the advisor must steward the action. That is why the standard is not perfect certainty. No advisor can prove the future. No advisor can eliminate uncertainty. No advisor can guarantee every outcome. But the advisor can prove what was known, what was assumed, what changed, what was reviewed, why judgment was applied, and why the action still deserved to happen. That is provable stewardship, and that is where Advisor Crunch fits. We are not telling advisors to fear AI. We are telling advisors to own their alpha before AI makes invisible judgment easier to overlook. The future advisor advantage will not belong to the advisor who uses the most AI. It will belong to the advisor who can prove where human judgment entered the process, who can show why the advice was client specific, who can document why the recommendation was still legitimate, and who can steward the client consequence before execution. That is tangible alpha. That is alpha ownership. And that is the work.